This is number 3 in a series of 5 videos we are doing with King County District Court. Our guest expert today is the Honorable Kristen Shotwell, who's going to be talking to us about what to expect during mediation. Welcome back, Judge Shotwell.
Well, thank you very much for having me back to talk some more about small claims.
So first off, why do parties have to mediate?
Well, our local court rule on small claims does require parties to mediate before a trial is set, but there are significant advantages to mediation over a small claims trial, and so we hope people will mediate in good faith, even though they're required to.
And what are some of those advantages?
Well, we find that people who mediate their small claims cases are much more satisfied with the outcome of their cases. And mediation is flexible. People can craft a flexible agreement. They can agree to do something or not to do something. And also, people who are owed money are much more likely to be paid if they mediate because they have arrived at a mutually satisfactory agreement during mediation. Whereas a party who wins at trial only receives an order, a judgment, saying somebody owes them money. And a judge doesn't just order the losing party to take their checkbook out and pay them right then and there. So collecting on that money judgment after trial often involves hiring a lawyer and other court processes such as garnishments and liens. So much more flexible and much more likely to get paid if people resolve their dispute through mediation.
Well, that's very good news. So what is mediation like in small claims court?
Well, mediation, first and foremost, is a private discussion between the parties. The judge is not present. The court staff is not present. The mediation is conducted by a highly trained professional mediator from the Dispute Resolution Center. The mediation occurs in a private room on Zoom, and no one is going to know what was said in the mediation, not even the judge.
And what are the possible outcomes of a mediation?
Well, the parties could end up agreeing to resolve their dispute out of court, meaning that there is no trial. If the dispute is resolved, the mediator will help the parties write an agreement that could be enforceable in court if one party doesn't live up to what they said they're going to do. If the parties do not reach an agreement through mediation, that's just fine. The case will be set for a trial in the small claims court in one of our courthouses.
Okay, so if the mediation fails, it will go to trial.
Yes. We'll be happy to set a trial date if they don't resolve their dispute through mediation.
Okay. Well, we're all worried about how long it takes to work with the courts in general. How long does mediation take with small claims court?
It really depends, but most mediations typically last between 1 hour and 3 hours. And it happens during the regularly scheduled pretrial hearing. So there's not a separate thing or hearing people have to go to. Sometimes the parties need more than 3 hours, and so they come back another day, but that's rare.
Okay, that's pretty quick, actually. That's good. So
Yes.
you mentioned earlier that one of the big advantages of mediation is people are more likely to get paid. But what are the other advantages?
Well, as I mentioned, mediation is private, whereas trials are public. We have open courts in Washington State. That means every word somebody says in court is a matter of public record. Every document, photograph, piece of evidence they hand up during the trial is public record. People are allowed to come and observe trials, and they're also allowed to request documents and the audio recording of the trial after the fact. And as I mentioned, though, nobody's present for the mediation other than the mediator and the parties, and that is not public record. The other advantage, that's a real one in this day and age, is that mediation occurs over Zoom, whereas trials in King County District Court must occur in person. So people have to come to the courthouse, find parking, bring their exhibits, and come down to the courthouse for their trial. But mediation is conducted over Zoom. And then, even there is an advantage to mediation, even if the parties do not resolve their dispute through mediation. We find that they are better prepared for trial. That is because they've had a preview of the other side's evidence and a preview of what the other side thinks about that evidence. And so it ends up being a strategic advantage sometimes, or at least just better prepared for trial because you know what your opponent's thinking.
Well, that certainly helps, doesn't it? Well,
Yes,
thank
it
you very
does.
much, Judge Shotwell, for this great information about mediation in small claims court.
Well, thank you. It's a wonderful program, and we're lucky to have the Dispute Resolution Center.
I agree. Thank you, and bye-bye.
Okay, see you next time.